I'm Eric Jaffe. I'm the chairman of the Free Speech and Election Law Practice Group, and we're sponsoring this panel. Just wanted to say hello very quickly and thank all of our panelists and our moderator for coming. Also want to thank you for coming and invite you to look at the work of the practice group, the Free Speech and Election Law Practice Group, and get involved in that practice group if you find our work interesting. And we're always looking for new members. We're always looking for folks interested to write and to talk and to do other things with us. And so welcome, and keep us in mind if you find this interesting, and if you don't, please help us do more. but I'm sure you will find it interesting because the topic is fascinating, and without further ado, I will turn it over to Judge Timkovich to introduce the speakers. Thank you.
Thank you, Eric. We have a really dynamic panel this afternoon, and I'm really pleased to be here to participate with really a distinguished group of panelists today. Our topic, of course, is the First Amendment and government benefits, and the group that we've gathered has really written and thought about this issue extensively. By way of background, the First Amendment and the Bill of Rights, of course, extended additional protections against government encroachment, and the speech clause of the First Amendment was an important element to support and shelter democratic liberty. But today we live in a world where the federal government has broadened its reach into the lives of individuals in a way that the founders would not have foreseen. The federal government today subsidizes all kinds of activities, either through direct benefits or tax exemptions or even tax mandates, and it has the power to attach conditions to that type of spending. Where to strike the balance between the individual's right to speak and the government's right to speak through its power to spend is an important question today in light of the changing legal landscape. The court first addressed this question in some detail in Rust versus Sullivan. In Rust, the court held that the Congress appropriates federal funds for a federal program. It is entitled to define the limits of that program. In other words, the government's decision not to fund programs as broadly as it could, in that case including funding on as a family planning tool, was not viewpoint discrimination. But in Rosenberger versus University of Virginia, the court held that a state university could not deny funding to a religious student publication if the university subsidized secular student publications. The distinction between the program and Rust turned on the identity of the speaker. In Rust, the government used private speakers to convey the government's message, but in Rosenberger, the university created a limited public forum to encourage private speakers to express their own viewpoints. Subsequent cases only illustrate the court's struggle to determine the constitutionally permissible limits of government speech versus impermissible regulation of private speech. In NEA versus Finley, for example, the court upheld a federal act requiring the National Endowment of the Arts to judge grant applications by certain criteria under the same government speech principle articulated in Rust. And 3 years ago in Christian Legal Society versus Martinez, the court upheld a state university requirement that all student groups who receive university funding admit members who do not share the organization's belief about religious or sexual orientation, because the all-comers policy was facially viewpoint neutral. But only a few months ago in AID versus Alliance for Open Society International, the court rejected a condition on federal funding to NGOs denying funding to organizations that did not have a policy explicitly opposing prostitution. The court held that this condition, unlike that in Rust, completely prohibited the NGOs from having any views on prostitution other than those espoused by the government, and therefore violated the First Amendment's prohibition on compelled private speech. Previous cases have articulated a relevant distinction in innumerable other ways that our panel will comment on. Is it possible for the court to clearly articulate a guiding principle to distinguish cases where the government can limit individual speech and cases where it cannot? In AID, an indication that the Roberts Court will scrutinize more closely conditions on government spending than it has done in the past. Our panel of speakers today will shed some light on the court's views on government subsidies and free speech. Our first speaker is Lillian Bevere. She received her bachelor's degree from Smith College and her law degree from Stanford Law School. She is currently retired, but she used to teach courses on constitutional law, the First Amendment, and campaign finance reform at the University of Virginia Law School. I currently teach election law at CU Boulder, and my text is replete with references to her scholarship on campaign finance and the First Amendment. Welcome, Lillian. Our second panelist is Marty Lederman. Professor Liederman received his bachelor degree from the University of Michigan and his law degree from Yale Law School. He is currently an associate professor at Georgetown University Law Center and was Deputy Assistant Attorney General in the Office of Legal Counsel in the Department of Justice from 2009 to 2010. He's also a regular contributor to the Balkanazer blog, Scottish blog, and Opinion Judas, among others. Our third speaker to my left is John Eastman. He's the former dean of the Chapman University School of Law and currently teaches there. He received his bachelor degree from the University of Dallas and his law degree from the University of Chicago. He's also the founding director of the Center of Constitutional Jurisprudence, a public interest law firm affiliated with the Claremont Institute, and he clerked for our dinner speaker last night, Justice Clarence Thomas. Our last speaker is David Cole. Professor Cole received his bachelor degree and law degree from Yale. He teaches constitutional law, national security, and criminal justice at Georgetown University Law Center. He's a volunteer attorney for the Center for Constitutional Rights. He's also litigated several Supreme Court First Amendment cases, including Texas versus Johnson, United States versus Eichmann, NEA versus Finley, which I just mentioned, and Holder versus Humanitarian Law Project. We'll start with Professor Bevere.
Thank you, Judge Timkovich. My fellow panelists are going to talk and concentrate on the two recent cases, USAID and Christian Legal Services. And I agree those cases are interesting and important and puzzling. Maybe they were rightly decided, maybe not. We will see. But I'm not going to talk about them right now. Instead, I'm going to take my few moments to look at the perfect storm that our topic as a whole represents. Now, First Amendment jurisprudence does not seem to have been consistently crafted of late with an eye to the maintenance of constitutional structure. In fact, it doesn't seem to have been consistently crafted with an eye to the maintenance of any particular value or to the performance of any particular constitutional function. And I think that's a problem. In the cases that we're talking about today, the amendment is being severely buffeted by the headwinds from several of the pathologies that characterize the modern welfare entitlement state. Now, I call them pathologies. I could call them structural distortions. Whatever I call them, there are those, and I think we have some on this panel who will disagree with me and take issue with my words, and perhaps we can talk about that. The first pathology is that the federal government seems to be ubiquitous. It has its hands in every pie. It regulates and generously subsidizes aspects of American life that were once thought to be the regulatory and funding responsibility of the states, of local governments, and of private citizens. Family planning, Rust versus Sullivan, the arts, NEA versus Finley, civil legal aid, Velasquez, Civil Legal Services Corporation versus Velasquez, computers in local libraries, American Library Association, behavior modification throughout the world to prevent the spread of AIDS, the USAID case. These are just a few examples of the regulatory reach and open-handedness of the federal government that the cases that we're talking about today talk about and are at issue in these cases. A second pathology has come in the wake of this open-handedness because, of course, where there are government subsidies, there are supplicants who believe themselves entitled to receive them, and not just entitled to receive them, but entitled to receive them on their own terms and not on the government's. The heavy seas of the culture wars represent the third pathology. Now, I'm going to drop the perfect storm metaphor. I hope it served its purpose, whatever I thought that was when I was writing these remarks. Several of the cases to which I've just alluded, Rust, Finley, American Library, and perhaps even USAID, are culture war battles, as of course are the cases that have arisen in public universities where politically correct academic administrators have engaged in ferocious clashes with the more deeply religious of their students. I'm speaking of Rosenberger versus UVA and Christian Legal Society. Those are just two examples. Now, we know that government is not required either to regulate or to subsidize any of the activities involved in these cases, and we also know that minimal rational basis scrutiny applies to the substantive decisions whether to subsidize or not subsidize. And all this essentially means that Congress or the administrators of public universities pretty much have a free hand. Finally, we know that why we're here today, is to talk about an important First Amendment exception to what I call the free hand rule, which occasionally kicks in when speech restrictive conditions are imposed upon subsidy recipients, so that in order to collect the subsidy, they're foreclosed from engaging in expressive activity that the government could neither prohibit nor punish outright. Occasionally. There's the rub. What that word means is that there's no hard and fast rule here. And what we're supposed to tell you on this panel is our thoughts about when a First Amendment occasion for striking down a condition on receipt of government benefits arises. How do you know one when you see one? Or how do you know not one when you see not one? Now, when I agreed to participate on the panel, I knew I'd have to revisit the cases. Not having taught my First Amendment course, or any course for that matter, for 3 years, about all I could remember for sure was that when I did teach them, my students and I were more than a little perplexed by what Kathleen Sullivan charitably called their doctrinal disarray. My perplexity reemerged in spades when I read the cases in preparation for the panel, and it was certainly not dispelled by these 2 recent cases of Christian Legal Society and USAID. For 2 reasons, I became more than a little depressed when I contemplated the lot of these cases. One reason is a reason I've already hinted at. I just became super aware of the stunning reach, ambition, and intrusiveness of government programs, and of the abundance of government largesse. But that's not the axe I'm here to grind today. The more important reason I became depressed is that I absolutely cannot make the cases yield to any coherent account. I can't discern from them what the First Amendment principle is that is at stake here. I can't discern why the First Amendment forecloses government from imposing speech restrictive conditions on receipt of government benefits in cases where the government wasn't constitutionally required to provide the benefits in the first place, and when the conditions leave the recipients as free to engage in speech on their own dime as they were before. Now, Marty Lederman noted in the course of our preliminary discussions that the issue of when is all case specific. And he's absolutely right about that. The cases will tell you when a condition is okay or not okay in First Amendment terms, but they don't tell you why. And to me, that fact is pretty devastating. For what it means to me is that when the court finds or doesn't find that a funding condition violates the First Amendment, its judgment is not constrained by any discernible, generally applicable, openly acknowledged criteria of decision. And excuse me, and this in turn means that the court is exercising essentially arbitrary power. I don't like that much. So I tell myself, calm down. Even if it's not clear on a fundamental level why the cases come out the way they do, it's still possible to sort the cases out in a moderately tidy way. Any competent lawyer can do this. Eugene Volok's casebook, for example, provides a disarmingly neat doctrinal summary. The government itself can say whatever it wants to say. It can pay private parties to convey its message and require that its money be used only to communicate what it wants communicated. It can impose rather heavy administrative burdens to make sure its money isn't spent for purposes it disfavors. But it can't impose conditions on how subsidy recipients spend money they get from other sources. When it creates a program that indiscriminately encourages a diversity of views from public speakers, government may not impose viewpoint-based restrictions. But if the program subsidizes private speech on the basis of quality or subject matter, then some content discrimination is both inevitable and okay, unless the court just detects not permissible subject matter or quality discrimination, but invidious viewpoint discrimination. Now, my problem with this summary is not so much that it's inaccurate. It maps, if rather crudely, onto the results of the major cases. The problem is that it's incomplete. For one thing, it doesn't in turn specify what the court does about subsidies that take the form of access to a public forum. More generally, its very tidiness sweeps under the rug a lot of mess, because the justices cannot seem to agree among themselves on how to characterize either the subsidy program or the nature of the condition at issue. In applying the analytical categories that Eugene's summary identifies, the justices have found occasion to disagree on their application in just about every case. They've disagreed about whether the program at issue is one in which the government is the speaker, or is it one designed to facilitate private speech. They've disagreed on whether the condition at issue merely defines the scope of a government spending program, or instead constitutes an impermissible viewpoint restriction of government-subsidized private speech. They've disagreed on whether the condition at issue is merely a subject matter restriction on speech in a limited public forum, or is instead a viewpoint-based. And the frequency and intensity of these disagreements suggests that the consensus that's apparently represented by the various analytical categories is so shallow as to render the categories useless as genuine guides to judgment. Indeed, the categories provide not criteria of judgment, but window dressing for subjective judgments apparently reached on other grounds. One thing is for sure. These cases are not poster children for rule of law values. So this is just for purposes of discussion. Let me pose a very quick question. On the merits, what would be wrong with the bright line rule here? Now, when Justice Souter was on the court, he seemed to suggest that the First Amendment prohibits any viewpoint discrimination ever in the exercise of public authority over expressive activity, even when the viewpoint restricting condition is part of the definition of the government program. Among its other virtues, such a rule would give clear direction to Congress about where the constitutional boundaries are. In addition, it might have rather substantial practical and political effects in that Congress might occasionally not be able to muster sufficient political support to pass some of its subsidy programs if it couldn't attach viewpoint restrictions to subsidized speech. Another possible bright line rule on the way the far other end of the bright line rule spectrum would be Justice Scalia's, to the effect that the distinction between abridging speech and funding it is a fundamental divide. And the First Amendment does not apply to funding decisions. Viewpoint discrimination is constitutionally unproblematic, says Justice Scalia, when government is not required to subsidize any of the speech at issue, and the recipients remain free to express their views on their own dime. In Justice Scalia's view, it is the very business of government to favor and disfavor points of view on innumerable subjects. Now, why isn't this right? Isn't that what elections are all about? So that the winners can pass legislation that embodies and even perhaps subsidizes their point of view and not other points of view. On the other hand, Justice Scalia's bright line rule turns out to be not so bright line after all. In the public university cases, he has sided with the justices who would use public forum analysis to invalidate what he has been quick to call discrimination against religious viewpoints, not just in denial of access for religious groups to a university's physical facilities, where forum analysis at least seems to be kind of a natural fit, but also in denial to religious groups of student activity funds, i.e., to funding decisions with regard to student speech on public university campuses, where not only does forum analysis fit less obviously well, but to which consistency might have required him to find the First Amendment just doesn't apply. Then again, his colleagues on the court, who are relatively quick to find find and condemn conditions on federal subsidy programs, are equally quick to think that what might look like religious viewpoint discrimination in university student funding decisions is something quite benign, merely subject matter, denial of funding for the subject matter of religious apologetics, or the enforcement of a laudable university-wide non-discrimination policy. Well, as I noted, to my mind, these cases are not poster children for rule of law values on the left or the right. I'm rather hoping that my fellow panelists will disabuse me of this conclusion, but if they don't, well, more's the pity. Thank you.
Thank you, Professor Bevere. Professor Liederman.
Thank you very much. It's a real honor to appear here at the Federalist Society on this wonderful panel about a recurrent and very fascinating topic. I thought I would take my time to use the most recent of these cases, one that many of you may not have focused on, as sort of a way to try to structure where the court is and thinking about where the court is. That's this AID case from last term that was decided in June. Professor Bevere bemoans what she calls the doctrinal disarray in this area, suggesting that the inability to reconcile, despite Jean Volok's best efforts, the inability to reconcile all of the decisions around some sort of neat rule of law rules probably betrays that the decisions have at least some measure of being decided according to the substantive predilections of the justices. To which my response is, as compared to what other area of Supreme Court doctrine, right? I don't know of any where that's not the case, or let me put it this way, the ones where they're pure rule of law that are not in doctrinal disarray are not the subject of Federalist Society panels. There wouldn't be very much to talk about. Having said that, I'm going to try to give Professor Bevere a smidgen of comfort by trying to structure, like Jean does, trying to structure roughly where the court is using this AID case as a prime example. And the court has, over time, sort of tried to split the world up into two different sorts of conditions, one of which is presumptively okay, the other kind of which is presumptively not okay or unconstitutional. But within the first, within the category of those that are presumptively okay, there is a very strong thread of a distaste for viewpoint discrimination in certain contexts, and I'll get into that. And by the end of my remarks, I thought I would also like to sort of just raise for discussion or Q&A three other things that I find interesting that this case and another recent case raise. Three different aspects of it. One is the role of the executive branch lawyer, the Office of Legal Counsel, and the question that some of you may have been interested in with respect to the DOMA case, whether the United States should always defend the constitutionality of statutes. Second question is, this case, or this series of cases, strikes me as revealing what I think to be an interesting divergence or difference between Chief Justice Roberts and his mentor, Chief Justice Rehnquist. They are typically very much of the same mind, but in this area, I think probably not. And the third is just to tee up something quite remarkable, which is apart from the First Amendment, and in keeping with the Chief Justice's views on this, that all of a sudden we see whatever rigor or juice the restrictive aspects of unconstitutional conditions doctrine might have in the individual rights area with respect to freedom of speech is for the first time being applied when it comes to conditions on states' receipts, on state and local governments' receipts of federal largesse. Obviously, what I'm talking about is the Medicaid aspect of the Affordable Care Act case. So let me tee up this case that was decided last June. It's Agency for International Development versus the Alliance for Open Society. And this involved a statute called the United States Leadership Against HIV, AIDS, Tuberculosis, and Malaria Act of 2003, or the Leadership Act. Professor Bevere referred to it as a case of behavior modification. I tend not to be too fond of behavior modification, but in this case, the purpose of this program is to modify behaviors around the world to prevent HIV and tuberculosis and malaria. And I count that as a good thing and a very much a function that is appropriate to the federal government. I don't know whether that view holds much sway here, but in any event, Congress surely thought so and decided that it was going to expend a lot of money to try to expunge AIDS around the world. President George W. Bush, this was a signal goal of his. He supported the act. And the statute provides a whole array of means by which the federal government might do so. The part of it at issue here is billions of dollars in aid to private organizations who are devoted to extinguishing HIV in particular, malaria and tuberculosis around the world, and who work around the world to do so through various means, working with governments, working with local populations, trying to change behaviors in various ways. So it's a typical cooperative spending program in which the government has an objective, can't do it all itself, and so enlists the help of private entities. The private entities that it chose were those that are most expert and most experienced and have the best track record in doing this, but Congress imposed 2 conditions on them receiving the federal aid to go ahead and go overseas and do this work. The first was not at issue in the case, and that's important to note. Everyone accepted this as legitimate. The first condition said you can't use any of this money to promote the legalization of prostitution. So there's a big debate worldwide about whether legalizing prostitution will either hinder or stop or exacerbate the problem of HIV spread. The United States Congress took the view, we think that prostitution leads to the spread of HIV, and we don't want to promote its legalization, and that legalizing it will make matters worse. Obviously, a controversial issue, but that's the position of the United States, and so none of the money here can be used to promote the legalization of prostitution. Fine, all the funding recipients agreed with that condition. The second condition required them, in addition, to adopt a policy or a pledge, it was called a pledge requirement, a policy that they were in fact explicitly opposing prostitution. And that was widely understood to mean explicitly opposing the legalization of prostitution as well. So Congress said you can only get the money if you actually have a policy in place explicitly opposing prostitution, and that is the condition that was challenged here. The court, by a 7-2 vote, held that that violated the First Amendment. The basic structure is this. The first condition is okay because it regulates the way in which the governmental money would be spent. We're giving you this money, we don't want you to spend it promoting the legalization of prostitution. Fine. But the unconstitutional conditions doctrine famously, in a series of cases, including Rust versus Sullivan, where this distinction was first really described in detail by Chief Justice Rehnquist, says that the government can't use its dollars as a carrot, as it were, to try to, in Chief Justice Roberts' words, leverage speech activity of persons outside the federal program. You can't offer someone a great deal, whether it be a teaching job, right, in a public school, or great funds to promote the eradication of HIV, as a means of getting them to change their speech outside the program. And in this case, compelling them to speak in a way to say something they don't believe or that they'd rather not talk about, which was the case with respect to these particular petitioners. They'd rather not take a position on the legalization of prostitution. You're compelling speech, something the government obviously could not do directly, couldn't pass a law saying everyone has to oppose prostitution. Here the idea was, and Chief Justice Roberts holds, that Congress was trying to leverage these very valuable grants as a means of getting these organizations who would otherwise be silent to publicly say, we oppose prostitution. That's an illegitimate objective. It's the government using its largesse, using the scope of modern governmental aid as a means of affecting the private speech market, as it were, outside the contours of the program. And that's, roughly speaking, the line that the court has tried to draw over the years. Within the first category, the use of the money within the program, there is, of course, a thread of cases in which certain conditions are unconstitutional, typically where the program itself is to promote a free speech market or a public forum, and the condition is viewpoint-based. So the classic cases are Healy versus James, Widmar versus Vincent, Rosenberger, and the like, where the state uses its money or its resources to create a private speech forum and says everyone but the people with this viewpoint may speak in that forum. In that discrete slice of cases of program-specific uses of funds, the court has said no. We'll talk about Christian Legal Society, I think, where the court said it was not within that category of cases. But otherwise, conditions on the use of federal monies are generally okay, as are prophylactic rules to make sure that that money is not used to do the things the federal government doesn't want to promote, but that the federal government can't use the dollars to leverage speech conditions that it couldn't impose directly. So let me quickly raise a third aspect that the federal government injected into the case at the last minute. So I'll very quickly say, the public record seems to express the view, I was in OLC at the time at the beginning of the Bush 43 administration, that at first when this statute was passed, the Bush administration OLC said that this second condition was unconstitutional, and the administration decided not to enforce the rule, not to enforce the law. And then it did a switch. And there's various public accounts of why. It was after my time, so I don't have any firsthand knowledge. I wouldn't say what it was if I did. But they decided, apparently, that at least a reasonable argument could be made that this was constitutional. So the government defended it up to the Supreme Court. And at the very end of its litigation, mostly in the reply brief, and in the quite, I think, very effective, but ultimately losing oral argument by now Judge Srinivasan when he was the Deputy Solicitor General, the government said, this isn't either of those two things. It doesn't fit in either of those boxes. What this is instead is just basically using someone's speech, either the existence of a policy against prostitution or the absence of one, as evidence of what kind of a group it is, so that we can make selective determinations of who is best, who's most worthy, who would be the best people to give these grants to. These are just discretionary grants. We only give them to certain applicants. We want the grants to be used in part to oppose prostitution. It makes sense that we would choose groups that are simpatico with that objective. And so we're using this not to leverage their speech outside the program, but to determine whether they are the best partners for us in this program. The Chief Justice did not say that would be an illegitimate objective. He leaves that question unanswered. Instead, he basically says, too little, too late. That's not what Congress was up to. Citing the Solicitor General's opening brief, he says, you've more or less admitted that Congress's objective here was to get people to make this pledge and to oppose prostitution, not to just choose who your best partners were. So I hope we'll have a few minutes to talk about that possibility. As Professor Cole and I discussed during the litigation of this case, it seems mostly like something like loyalty oath cases, right, where teachers were required to demonstrate that they were federal employees, loyal to the United States. And the case law on that is not nearly as uniform or as clear as I remembered it to be from the 50s and the 60s and the 70s. It's really still an open question whether and when a federal government or a state government or a local government can impose conditions on who it hires based on their outside speech, not in order to punish that speech, but in order to determine who would be the best employees or grant recipients. Something to watch in future cases. I would say quickly on the final 2 points. So one, Chief Justice Rehnquist was famously the most aggressive justice in terms of believing that you have to take the bitter with the sweet. Any speech, any conditions on funding, as far as he was concerned, were okay, no matter what. You could try to coerce the outside speech market all you wanted, because you could always turn down the job, turn down the grant, turn down the largesse from the government. So the chief was a big believer that there was very little of unconstitutional conditions, doctrine notwithstanding the Rust decision, where he might have needed to say so to get his fifth vote. Chief Justice Roberts seems very much otherwise, both in the healthcare case with respect to states, which is the last point I wanted to make. In this case, he's in the dissent in the Christian Legal Society case. And interestingly, in the Rumsfeld versus Fair case, some of you might remember that as the Solomon Amendment case that required schools not to discriminate against, not to exclude military recruiters from their recruitment fairs. The Chief Justice wrote for the court on this issue, and he had a lot to say about it, but ultimately did not rely upon the spending power of the government for that. He said instead that condition could be imposed directly under the Congress's raising the Army and maintaining the Navy clauses. And so I think that this Chief Justice is much more uneasy than was his mentor, Chief Justice Rehnquist, about the state using conditions to coerce speech or even to impose conditions within the spending program, as in Christian Legal Society. Finally, of course, what's the most remarkable spending clause decision of the last few years doesn't come in the First Amendment area at all, but is the Medicaid section of the Sebelius versus NFIB case, in which the Chief Justice in particular, and would have been even more aggressive, the opinion for four justices, Scalia, Thomas, Kennedy, Alito, would have been even more aggressive this way. But even the Chief's opinion for himself and Justices Breyer and Kagan, for the first time really in our nation's history, says just as to individuals, just as you can't use money to coerce individuals to do what you couldn't do to them directly, so too at some point you can't do that to the states. You can't require states, you can't coerce is the verb there, right? Similar to leverage in the AID case. You can't coerce the states to do something they don't want to do by offering them a huge pot of money to do something they do wish to do, right? You can't tell them, in order to get this pot of money, you have to do 100% of what we want you to do. They have to be able to pick and choose, at least at some level, which parts of the federal program they will use the money to enforce and which they won't. Of course, the future of that state-specific spending clause doctrine remains to be seen. NFIB, most of you probably know, raises a slew of questions that will keep us academics in clover for many, many years on that score. Maybe it'll become just as doctrinally in disarray as it is in the individual rights context, in which case we can have many more panels like this one. So with that, I'll turn it over to Professor Eastman and talk more, I think, about the Christian Legal Society case.
Thanks, Marty, and Professor Bevere, and Professor Cole, and of course Judge Timkovich and the Federalist Society. I normally don't do the free speech panels. I'm normally over in the other room on the federalism panel, so I'm on uncharted territory here. But sometimes somebody that comes in and doesn't spend all of their time in the weeds of a particular doctrinal area can see some connections or oddities that in our own areas we often don't see. So let me go through a little bit more on a couple of the points in the language from the aid case that Marty was talking about. So I think we're in full agreement. There was really no issue. Pretty straightforward application of Russ versus Sullivan, the prohibition on any of these fundings being used to promote the legalization of prostitution. And then the other condition, what they call the policy condition, that no funds may be used by an organization that doesn't adopt as a policy a position explicitly opposing the legalization of prostitution and sex trafficking. Now, here's the language of the unconstitutional conditions doctrine that we're all familiar with. The government may not place a condition on the receipt of a benefit or subsidy that infringes upon the recipient's constitutionally protected rights, even if the government has no obligation to offer the benefit in the first instance. Right? And so you set this out that there's something out there. A condition that compels a recipient to espouse the government's position on a subject such as this of international debate cannot be squared with the First Amendment. That was the holding of the district court, and largely in different terms ratified by the Supreme Court. And then they try and draw this, what the court considers to be hardly a clear line. The relevant distinction that has emerged is between conditions that define the limits of the government spending program, those that specify the activity that Congress wants to subsidize, and conditions that seek to leverage funding to regulate speech outside the contours of the program itself. So that's where they claim the line is, but it's so unclear that they admit in the very next sentence the line is hardly clear. And then we close with even a more clear line, how it applies. If there's any fixed star in our constitutional constellation, it is no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. Obviously from Barnett and that wonderfully flowery language. But boy, there's a whole lot packed into that the court just glosses over in the aid case. And so I look at Scalia's dissent, and I have to say, as a kind of an initial read of it, that when the government, if you concede that the government has the ability to speak and offer its own position on contested matters, that surely it can pick people to engage in that speech who agree with it. Now, granted, this is the fallback government position that not really well articulated until their reply brief, but let's not look at the briefing schedules in the case. Let's look at the doctrine. There's much to commend at, it seems to me. If government is merely selecting an appropriate spokesman to implement the government's chosen strategy, then it ought to be able to do that. The First Amendment, Justice Scalia says, does not mandate a viewpoint-neutral government. Government must choose between rival ideas and adopt some as its own. It does that all the time. And it may enlist the assistance of those who believe in its ideas to carry them to fruition. Justice Scalia says, characteristic line, that seems to me a matter of the most common sense. I don't know what the least common sense would be, but he thinks this is among the most common of common sense matters. As I drive in California all the time and we see our tobacco ads on the screens, if I were a private business, put such ads up, I might be charged with various violations of federal law, but the government has a way to do those things. Now, then Justice Scalia closes with the fact that the Constitution itself requires an ideological commitment. He says Americans don't need to support our Constitution. They can be communists or anarchists. But if they want to hold office, they have to take an oath to support the Constitution. That's an ideological commitment for access to a government program, holding office or sitting in Congress. He says the framers saw the wisdom of imposing affirmative ideological commitments as a prerequisite to assisting in the government's work, and so should we. All right, and that sounds right at some kind of intuitive level. I think there's much to commend the reasoning of that. But I want to explore it a little further by looking at some analogous circumstances. And so the Christian Legal Society case versus Martinez comes directly to mind. It's a 5-4 decision from 2010. The Christian Legal Society had a requirement that you be Christian in order to be a member of the Christian Legal Society. Hastings, and there's some great dispute in the record over what Hastings' policy began as versus what it developed into during the course of its litigation. But it came to the view that in order to be a recognized student organization at campus, the student groups have to allow any student to participate, become a member, or seek leadership positions in the organization, regardless of their status or beliefs. And so that meant that the Christian Legal Society had to admit members who were decidedly not Christian, who questioned the Christian beliefs and the requirements. They forced the La Raza, which had as a requirement before this litigation that you be a member of the Mexican race, to change that requirement. The Democrat caucus had to accept Republicans in as members and leaders, and vice versa. I'm reminded of a fight we had on our faculty at one point on this issue, and when they told me I couldn't bring in interns from a group that was religiously affiliated because they discriminated on the basis of religion, I pointed out the hypocrisy when our next motion on the faculty meeting's agenda was to nominate our Law Woman Student of the Year. When I complained about this, that I violated our policy against gender discrimination as much as the religious discrimination, they said, well, men are open to that award as well. And to prove it, they nominated a man the following year. He didn't get enough votes, but they just wanted to prove the point. Now, this policy that Hastings adopted made the Christian Legal Society ineligible for recognized student organization service status, but also all of the affiliated benefits. Because its charter required, as I said, members to sign a statement of faith supporting the tenets of Christianity. Now, CLS is a public forum case, so it's not directly a government speech case. But it's a limited public forum, not a designated public forum, and I think that is critical because a limited public forum makes it much more like a government speech case. The decision in the case turned on the court's recognition that implicit in the concept of a limited public forum is the state's right to make distinctions in access on the basis of speaker identity. And so unlike a designated forum where I'm really opening something up that's normally not a forum to a forum, it's all private speech that I've opened up. The limited public forum is the government is defining the contours in order to further a government mission by piggybacking on the use of certain speakers that will invite to the forum. And that makes it much more like a government speech case, it seems to me, than we often think. In other words, the foundation of the limited government forum is that it is furthering some governmental purpose as defined by government, much as is the case with government speech case. And then in the course of the opinion, the majority notes that the law school views that an all-comers policy, this is its forum, to the extent it brings together individuals with diverse backgrounds and beliefs, encourages tolerance, cooperation, and learning among its students, and that's its objective for creating this recognized student organization, limited public forum. That's government speech, it seems to me. Moreover, it was not a traditional limited government forum, but it was also a metaphysical one. We had physical forum where you got to post notices on the bulletin boards and use the school's email system for distributing meeting notices and use the classrooms. But it was also a metaphysical forum. You got access to student funds to buy pizza at your meetings, I gather, if you kind of qualified as a RSO. Now, I want to leave aside for today's purposes whether this is really a subsidy, as Justice Ginsburg characterized it in the opinion. The money was, after all, collected via mandatory student fees that the students had to pay and then redispersed to the very same students only if you met the government's conditions. CLS students were paying into the pool, but because they were not eligible, they didn't get back any of their own share of the funds. Let's leave that aside for a moment. Even if we just treat this as student funds and other access right as simple, straight government benefits, the simple fact is that CLS was not eligible for the benefit because it could not subscribe to the government's preferred speech and association policy. That sure sounds an awful lot like the aid case to me. And moreover, the court applied what it called its less restrictive limited public forum analysis because of the fact that Hastings, through its program, is dangling the carrot of subsidy, not wielding the stick of prohibition. That too sounds a lot like the aid case. In fact, I wrote down, Marty said, government can't use its dollars as a carrot to leverage speech outside the program. I'm using almost exactly the same language. Now, and the court gave deference to the college's program purpose because a college's license to choose among pedagogical approaches is not confined to the classroom. For extracurricular programs are today essential parts of the educational process. In other words, the RSO program was designed to further the government's purpose, not just to provide a forum for private speakers to further their purpose. Again, that sounds an awful lot like the aid case to me. And yet the court held in aid that the restriction there infringed First Amendment rights of the private speaker, but the court in CLS held that the restrictions at issue there did not infringe the First Amendment rights of the private speaker. If you line up the justices, you'll find that most of the justices split their votes on this. There were only 2 justices that came out in favor of the speaker's First Amendment rights in both cases, Chief Justice Roberts and Justice Alito. Justice Stevens and Kennedy, Ginsburg and Breyer and Sotomayor, and then I'm going to put in Justice Kagan there as a swap for Stevens, even though she was not on the first case and recused in the second. But I think it's a fair, I'm probably going out on a limb there, but I think it's probably fair. They all supported the government in the CLS case, but the speaker in the aid case. And then Justices Thomas and Scalia supported the speaker in the CLS case and the government in the aid case. So what's going on? So no one voted for the government in both cases. Everyone else split in these odd positions. Now, I suppose the cases can be distinguished. The benefit provided by Hastings, for example, was much more directly the student's own money than the benefit provided in the aid case. And the government in the aid case had a much more specific government speech mission. The limited forum aspects of the CLS case makes the government purchase much more ephemeral and indirect, it seems to me, to further this inchoate educational policy by letting private groups speak for themselves. Those distinctions would explain the split votes, I think, by Justices Scalia and Thomas, or at least could. I find it much more difficult to find grounds for distinguishing the cases in ways that explain the split votes the other direction, those of Justices Kennedy, Ginsburg, Breyer, and Sotomayor, and then Stevens and Kagan, given the assumptions where they might have been on each of them. That suggests a much more problematic explanation, and I line up directly with Professor Brevier. That problematic explanation that CLE's membership policy or decision not to embrace the government's relativistic message as its own was a less favored message than AID's policy not to embrace the government's anti-legalization of prostitution message as its own. But isn't that just what Chief Justice Roberts held in AID? That the government cannot leverage its funding to regulate speech outside of the contours of the program itself? Now, while we ponder the implications of those observations, let me shift to another set of recent factual circumstances that come at the problem from yet a slightly different angle. Some of you may have seen my testimony last June before the House Ways and Means Committee, addressing both the slow walking of nonprofit status application by conservative groups and the illegal disclosure of tax return information of the organization I chair, the National Organization for Marriage. Now, I was on the receiving end of a rather lengthy harangue by Representative Earl Blumenauer about how the National Organization for Marriage didn't even deserve to be a nonprofit because nothing it did served the public good. And he ran the clock out on me, so I couldn't immediately respond. But when I got next a question from the other side of the aisle, I kind of turned my sights back on him for a moment, and I took the opportunity to chastise him for the view that government got to define which organizations furthered the public good and which did not, at least when dealing with hotly contested political issues such as the definition of marriage. And I also chastised Representative Doggett for his statement that educating people about the Constitution was a partisan political issue, and therefore that groups that espouse such a mission should not be eligible for nonprofit status. Right? Now, you start to see the problems with this government speech line when it extends to any benefit which would include subsidies by way of a tax-exempt status. Consider the definition used in the Bob Jones case, for example, and you can see the potential breadth of the problem. To qualify as a 501c3 charitable organization, you must serve a public purpose and not be contrary to established public policy. Well, with the increasingly expansive view of permissible government speech setting out what constitutes established public policy, you can see how increasingly the levers of government are being used to weigh in on political disputes about the size and the scope and the purpose of government. And then when the First Amendment is selectively applied to protect some speech, as in the aid case, but not other private speech, as in the CLS case, government ends up not just advancing its own cause, but shutting down contrary speech. It seems to me that's not a very healthy development in democracy, where the government is supposed to be the agent of the people rather than its lord and master. So I guess where I'm ending up at the moment is that we need to be a lot more suspicious of government speech across the spectrum than we have been heretofore. Inconsistent application, as I think is evidenced in these cases, and risk of abuse is simply too great. Thanks so much.
Professor Cole.
Thank you. I'm delighted to be here and to be on this panel. I'm in the often the not infrequent position of being last on the panel where everything has been said, but just not by me. So I will try to comment on what my predecessors have said as much as set forth my own set of views. But I tend to agree with both Professor Brevier and Professor Lederman that this is an area where there is a great deal of disarray, but that doesn't distinguish it from most areas of constitutional law, and particularly areas of First Amendment law. So the prohibition, everybody agrees that prohibiting speech directly raises First Amendment issues, even if there are some who believe that using government funds to affect speech should not. But even in that area, there's tremendous disagreement, and many decisions come down 5-4 and the like. So these are hard issues. I think, as Professor Brevier suggested, neither of the simple solutions really work. So the one simple solution is he who pays the piper calls the tune. There is no such thing as an unconstitutional speech condition on government funding, because the individual can always choose freely not to take the money and therefore to be able to engage in his or her speech freely. And that argument has been advanced often by Justice Scalia, although not consistently by Justice Scalia. It's been advanced by the Washington Post. It was advanced by the Washington Post in support of the decency clause that I was challenging in NEA versus Finley, which required NEA grants to take into consideration general standards of decency and respect for the beliefs and values of the American people. They said, like Justice Scalia, well, it doesn't restrict any artist's speech because an artist doesn't have to take the money. They can still engage in free speech. So that's the one simple view. And the other simple view is the government should not be engaging in content and viewpoint discrimination, period, whether it's funding or whether it's regulating directly. The power to fund is a very, very significant power, and so we ought to impose the same rule on both sides. Neither of those really works. And in particular, the he who pays the piper calls the tune argument doesn't work because, as I think Professor Eastman intimated, virtually every forum of public debate in the United States is government subsidized, including this one. Right? Your contributions to the Federalist Society are 501c3 supported, and so there is a federal subsidy to this very forum and everything that the Federalist Society does. So if he who pays the piper calls the tune, would it be constitutional for Congress to give 501c3 subsidies to the American Constitution Society, but not the Federalist Society, or to the Federalist Society, but not the American Constitution Society. I don't think we would be happy with that kind of result. I don't think Justice Scalia would be happy with that kind of result, and yet that's the implication of he who pays the piper calls the tune. Similarly, the notion that the government should have the same kind of obligation to be content and viewpoint neutral, whether it's regulating directly or whether it is allocating a benefit, really doesn't work. I mean, content restrictions are necessary. If the government wants to fund research on cancer, it can require the person who gets that grant to spend his money researching cancer rather than going to Bon Jovi concerts, right? And they have to have that kind of content restriction in order to make the program worthwhile. The government also often needs to engage in viewpoint discrimination. The government, if Jay Carney came out tomorrow and said, you know what, I've come to the conclusion that Obamacare stinks and is unconstitutional, he'd be fired because of his point of view, and no one would question that it's permissible to deny him a job and deny him whatever government benefits he gets from that job based on his viewpoint, because the government, as Justice Scalia has said, needs to be able to express its viewpoint, needs to be able to pay people to express its viewpoint, needs to be able to fire them when they don't express its viewpoint. So neither of those polar extremes works. And I want to just, and so I want to suggest sort of where we are and where we sort of need to go if we are going to make sense of this difficult area in the middle. I think one thing to keep in mind is that, as I said before, the ubiquity of government funding in speech contexts means that we should be very skeptical of this notion that, well, someone can just walk away from the government money and therefore we shouldn't be concerned about the way the government conditions that government money. Take mailing subsidies for newspapers and magazines. That's a subsidy. Could the government say, well, we're just going to subsidize the newspapers and magazines that we like? Or the broadcast airwaves for talk radio and television. That's a public subsidy. It's a grant of a publicly valuable good to broadcasters. Could the government start to put conditions on the content and viewpoint of what people say because they're using the public airways? NPR receives direct government subsidies for its speech. Should the government be able to control its speech so that when a Democratic president is in power, it espouses Democratic points of view, and when a Republican president is in power, it espouses Republican points of view? Or should it be free to espouse Democratic points of view whenever it wants to? Public universities, right? Public universities, where Professor Bevere was employed for most of her career. Should the government be able to oversee what she writes and what she says and deny her tenure or fire her because it doesn't like the politics of her points of view? So I think the point should be clear that we need an affirmative First Amendment doctrine to deal with the conditions imposed on government subsidies, or else there won't be much left of free speech and free debate in American society. Those subsidies aren't going to go away. 501c3 isn't going to go away. Public universities aren't going to evaporate. NPR might, but the rest of them are here with us for the foreseeable future. What has the court said? Well, I think what it said is relatively limited. One thing it has said, and I think the AID case is an example of this, is that while the government can generally, when it is speaking, control the content of the speech itself that it is funding, It can tell people you can't advocate prostitution. It can't go beyond that and try to control what the recipient says or believes on its own time, on its own dime. That's a pretty straightforward restriction. Sometimes it's hard to draw that line, but I think that's a restriction that makes sense. The second line that it is drawn is to say that where the government is engaging in expressing its own point of view, it has fairly wide latitude in controlling the content of what is said, but that when it is engaged in this, in kind of supporting forums of expression or political activity, which is what 501c3 is, what the broadcast media is, what mailing subsidies for the press are, what public forums are. I think public forums is just another version of this same problem, right? It's just another form of a government subsidy to say you can come onto government property and speak. When a public university creates a student group policy, in those contexts, it has to be much more content and or viewpoint neutral with respect to the way that it allocates its subsidies. And I think that that distinction makes sense. That it's again difficult to draw, but what it requires us to do is to identify spheres of neutrality, spheres of government funding, where even though the government's paying the dime, important First Amendment interests require free, uninhibited exchange of ideas, and the program can work consistent with that. So 501c3 subsidization of charitable organizations can work without having to distinguish between conservative and liberal. And similarly with subsidies of student groups, and similarly with subsidies of the press and the like. And they're also critical because those are precisely the fora in which we, as a society, debate the values that we hold most dear. I think I'll just stop there so that we have time for conversation. But just to say, I agree this is a difficult area, but I think it's an absolutely critical area, and it's a critical area for resisting the notion that the sort of simple and sometimes seductive, because simple, but I think deeply wrong notion that if the government is paying the piper, it should be able to call the tune. Thank you.
Thank you, Professor Cole. We're now going to have some additional comments from the panelists, and then we will reserve some time for questions from the audience. There are microphones there, and when I open it up for questions, just walk up to the microphone, and I will recognize you at that time. Well, first of all, I guess let's go back to Professor Bevere. Has the panel brought order to chaos?
What do you think? What they've basically said is, so's your old man with respect to the disorder here. And I take that criticism. Of course it's true. But, you know, we try to take these things one at a time, which isn't always the best way to clarify anything. But, you know, I was asked to talk about First Amendment and conditions on government funding, and so that's what I did, and I looked at it. It was a mess. So, but I think what they've tried to do, and I appreciate it very much, and you know, I'm sort of one of those people. I had a lot of law students like this who would read the majority opinion and say, that's right, and then they'd read the dissent, they'd say, that's right. And so there's a lot of stuff that was not, there were a lot of comments today and a lot of analysis that seemed to me to be correct. So I confess too that I'm not, you know, I can look at these two polls. I understand that they're overly simplistic and they don't sufficiently accommodate all the complexity of the fact that government is out there doing everything. I can think about those. I see why they don't work, but I don't see what the alternative is, except this kind of case by case. Well, it's sort of this, but if we think it's not really private, subsidizing private speech, well, we'll call it something else. We'll call it the limits of the government program. So So I still think it's hard, so there.
You taught campaign finance and have written extensively on political speech. In light of the Citizens United opinion and the increasing use of PACs through the C3, C4 form, do you see the court starting to be concerned about this divide? Both Professor Cole and Professor Eastman talked about that in the area of tax exemptions. What's your take in light of the court's more recent campaign cases?
Yeah, that's a really good question. Let me talk just for a minute about these the tax exemptions, because it seems to me, I mean, I think there's a real problem here whether you can get at the tax exemptions directly with the First Amendment, okay? Because in terms of what the court has basically said with respect to what the ability to subsidize one activity and not another, and to make choices so long as they're not, and to make choices. Justice Scalia, in one of his opinions, and I wonder if any of the panelists remember this, he said something, and it was one of the opinions in which he was affirming his position about funding conditions being okay and abridging being not okay. He said that, of course, the government could not discriminate in a funding case between Republicans and Democrats. But then he said, but that's not a First Amendment problem. So I'm very confused about why that wouldn't be. But he also said that the vagueness doctrine does not apply to conditions on spending. And I think that's what it seems to me that part of the difficulty here is with respect to these tax exemptions is that what happened apparently in the most recent flap is that all of this discriminatory behavior, if that's the way you want to call it, by the government took place under a cloak of a neutral rule, and it was very hard to discover it. And when you find out about it, you're appalled. At least I was, and I would think I would have been appalled under a Republican administration. Have Republicans been doing it? Because I just think it's completely the wrong way for these low-level officials to be operating without people able to see it and to correct it and to bring it to light. So, but I'm not sure that that's a First Amendment problem. Now, maybe it is, but I'm not sure what the First Amendment doctrine would say if it is.
Thank you. Professor Liederman, what do you think?
Well, a couple of comments. One, I think you're right. It's always intrigued me that those who are strongest on he who pays the piper calls the tune, Rehnquist and Scalia. I think it was first in Chief Justice Rehnquist's dissent in the Southeastern Productions versus Conrad, and maybe in the Arkansas versus Forbes case where Scalia said Democrat, Republican, that would be a line that would just fail, I think, due process rather than the First Amendment. It's sort of an interesting notion. On the tax exemptions, I'm not sure. I mean, this goes back virtually to the beginning of the modern era of unconstitutional conditions doctrine, to the Regan versus taxation with representation case, where the court said that to get 501(c) status, you have to agree that you won't lobby. And they didn't have any problem with that at all if you could lobby by setting up a 501(c)(4) to do so. And there are plenty of conditions. The Bob Jones case John raised. I mean, there are a whole slew of conditions that are acceptable for the receipt of particular tax benefit treatment. And as long as it doesn't seem to be a condition that is trying to skew the speech market, I think the courts will continue to uphold those. I did want to speak briefly to John's doubts about whether you could reconcile the majority opinions in the AID case and the Christian Legal Society case. I think what the Ginsburg part of the court would say, she wrote the Christian Legal Society case, is that it's reflected exactly in Chief Justice Roberts' opinion in AID. That is to say, the Christian Legal Society condition was only about what the rules would be, that you couldn't discriminate on the basis of religion, with respect to getting the recognition within the Hastings School of Law. And she said it bears repetition, and she repeated that about 3 or 4 times. She kept saying, it bears repetition that CLS can have whatever rules it wants outside the Hastings Law School if it doesn't want this particular government benefit. So it was not a case in which the government was trying, or the law school there, was trying to leverage its benefits in order to get CLS to change its perspective or its views or its membership criteria outside of Hastings Law School. Now, that doesn't make it constitutional, right? That simply raises the question about whether the particular it just makes it, in my view, completely reconcilable with the AID case. But it still raises the question that Justice Alito probed in his dissent about whether within that program it was closer to the sort of condition that was skewing a speech forum like those in Widmar, Healy, and Rosenberger, or was not, as Justice Ginsburg said. And if you haven't read it yet, I mean, the most remarkable opinion in that case in some respects is Justice Kennedy's concurrence, which is reflected in Justice Ginsburg's majority, but is even stronger. Justice Kennedy really thinks this is not only a permissible condition, but he suggests quite strongly that it's one he deeply believes in. When you're in law school, he says, the whole point is not to be among all people who believe what you do and who are all on the same page as you. You're learning to be a lawyer, and the school is not only permitted to, but he seems to be saying it ought to be requiring you to engage with people who have views that are different from yours in every aspect of your education, not just in the classroom, but in the extracurricular activities as well. And that pedagogical value in exposing you to the views of dissenters from within a Christian tradition or from within whatever tradition your group happens to be is not only a permissible state interest, he says, but he seems to suggest it's one of the more important ones within a body of higher education. Now, that is an extremely provocative viewpoint, but one that's much worth discussing, I think.
Thank you. John?
Yeah, no, I mean, I know that they said that. I just don't find it very consistent with what they actually did and compared to what they did in the aid case. You know, Justice Kennedy says that, but you know, I mean, it belies credibility to think that the Democrat Club has to, you know, elect officers who are Republicans in order to be a recognized student organization. Now, I know during the course of the litigation they entered into a stipulation of that fact, but there were answers that were filed by Hastings early in the case that should have been binding on them that said, yeah, we recognize that some of these groups, we're just not going to do it here because it violates our non-discrimination policy. There's something much more invidious going on that the language in the opinions is trying to gloss over. And I think at bottom, it's that this is not a trigger on or off issue. It's a spectrum. It's a continuum. And so, you know, no matter how much Hastings' position now asserts that it is open to any group that says we're open to all comers, if the Neo-Nazi Association of America wanted to create a recognized student organization on Hastings campus and said we're going to be perfectly happy to accept into anybody of whatever race or religious background they want, you know, we won't promise you how we're going to treat them once they're in our organization, but we'll let them become members. Hastings would not give them recognized student organization status, nor should they. Right? And so the question is, where from that position does government get to make the judgment that the fight over CLS's position on traditional marriage versus same-sex marriage is of that nature versus a contested political fight that the government not ought to be weighing in on? And that, I think, is a much more difficult question. And where to try and draw the line on that continuum is where I think the fight ought to be. And neither of the decisions in the two cases even begin to address it in those terms, it seems to me.
David, how do you see the line drawing exercise?
Between Christian Legal Society and AIG? Well, you know, I tend to agree with Marty that AID was a case in which the government was explicitly seeking to impose a restriction not only on its own funds, that was Part A that nobody challenged, but there was a Part B, and as Chief Justice Roberts said, Part B did something beyond that, and it's the going beyond that that was problematic. Whereas in Christian Legal Society, I think, you know, the nature of limited public forums is that some line drawing is permissible, and some other line drawing is not permissible. And so, for example, had they said, and you know, whatever the reality was, and I you know, yield to Professor Eastman on what the reality was, but of course, when you're litigating in the Supreme Court, it's not reality that matters, it's your stipulations that matter. And the stipulation said this is an all-comers policy. It's a neutrally applied, all-comers policy. The only thing we require is that student groups be open to all comers. That's it, and it applies across the board, doesn't it? And you know, to me, that's not that different from a policy that says we'll only allow student groups to use our rooms, you know, at certain hours of the day or night, or we'll only allow student groups to use our rooms if they don't allow outsiders to come in without first obtaining our permission for neutral safety reasons. These are sort of time, place, and manner type of restrictions, and so I think that's how the court saw that. But it is a situation in which if the definition of your association in some sense requires exclusion of others, then it has a disparate impact on you, to be sure, and that's what makes that the case difficult, I think.
So can I ask a question? Do you think that, I actually have two questions. One is whether anybody agreed with me, I think the answer to this one is no, but that's okay, I'll ask the question anyway. When you read the Christian Legals, when you read the USAID case, one of the things that jumps out is that the reason these recipients did not want to take the condition was that they disagreed with the policy. And they said, we cannot be as effective with governments who think that prostitution should be legalized, for example. So we disagree with the policy that's represented by requiring us to. So it seemed to me that if that's the case, then the First Amendment argument for them was merely opportunistic. And maybe that's perfectly fine. It doesn't detract from its validity. But it struck me that, oh, see, here's the First Amendment. It's just available for anybody who doesn't like anything. And you can sort of stomp on the legislation in that particular way. And secondly, well, I'll just leave it at that, because I forget my second point.
You know, I mean, I think all law is opportunistic. You know, I think many of the challenges to Obamacare were opportunistic, but that doesn't mean that they're not serious challenges. And I do think that I guess I don't think that taking the position that the position that they took was we want to remain neutral on prostitution. Because in order to be able to work with some of the groups that are most at risk here and that need to be educated are prostitutes. And in order to work with them, we just want to remain neutral. So that was their judgment call, and that's a legitimate judgment call. They might take a judgment call the other way, but their argument is we should not be compelled by the government by virtue of a condition on spending money to do something the government wants us to do, and we're totally willing to spend it in precisely the way the government wants us to, and to not say a word that is inconsistent with government's policy. But we don't want to have to adopt a policy that we don't believe in. To me, that's not opportunistic. That's the core of what the First Amendment is about, which is freedom of belief.
I would add, I may have left I don't know if this is on, can you hear? I may have left a misimpression, and I apologize, Professor Bevere, if I did. This program did not require the recipients of the money to go out into the world and oppose prostitution on behalf of the United States. If that had been the funding program, here's a funding program the U.S. is going to go out and try to end prostitution by promoting its prohibition in every nation on earth. You get to have money. Who wants the money to go do that sort of thing? I don't think any justice on the court would have said to an applicant, you can take that money and not oppose prostitution using that money, right? That would have been a perfectly permissible condition. But the program did not require that to happen within the program itself. And so the groups were saying, why should we have to oppose it outside the program if you don't even require us to oppose it inside the program?
No, I understand the
Well,
First Amendment
we'll go ahead and take some
Yes.
questions from the audience as Professor Bevere is commenting.
Absolutely, that's fine. Go ahead.
Do we have some questions? Yes.
I think I'm known for always having a question. I'm struck, although Professor Eastman set it aside, I began this debate a little bit by accident by bringing this case up yesterday in an earlier panel, and you had suggested that this was a matter of student fees in CLS, I actually had a conversation with Eugene Volokh, and he maintained the opposite. And it might be a misunderstanding, but I think that is a semantic, but I think it's a really important semantic, because I might be with Justice Kennedy, that pedagogically speaking, if this is about your education in a much larger way, and you put it under the tuition, and this is simply an extracurricular, but it's a tuitioned activity related to your education as a law student, I might agree with Justice Kennedy. But if these are student fees related more to a sense of social, cultural, or whatever activity on campus while you're there, some larger sense of life, those are mildly related to education and growing and maturing, but I don't see them.
Let's get to a question.
But do you think that's important? You set it aside, but I think it's really critical.
Yeah, no, look, if I can tax everybody in the room $10 and then decide for a social party fund, and then give you access back to your own money only if you agree to accept my conditions on how you use it, I think it's different in kind than if I'm offering you a benefit from the front end that you didn't contribute to the pool on, and that's what I was suggesting. And that, I think, is what every university uses these student fees. We charge you for your outside the classroom activities, because we think leadership skills and diversity of groups, we think it's good that we have a Democrat caucus and a Republican caucus. We think it's good that we have La Raza and the Christian Legal Society. But now all of a sudden, for the first time in our history, we deny recognition to the Christian Legal Society. Here's the answer to the complaint that Hastings filed. They admit that the current policy permits political, social, and cultural student organizations to select officers and members who are dedicated to a particular set of ideals or beliefs. And we want to encourage a diversity of those organizations to give students a lot of opportunities to further their own views on this. But when the one that comes along that we don't like, Christian Legal Society, because they've said if you're going to adhere to the standards of the Bible, that means you really ought not to be engaging in sex with people of the same sex, and we're going to make that a condition on your membership in our organization. Well, that one you don't get recognition of, because furthering those beliefs is no longer part of what we wanted to create this limited government forum. And the power of the government to make that decision on such a hotly contested issue, I'll leave aside for the moment the real extreme ones that I gave her, but on such a hotly contested issue, when, as Professor Bevere has pointed out, the government has become so ubiquitous in its funding, really does then, the government becomes its own advocate for its own positions and can start silencing other views, and I think that's a very dangerous thing.
Thank you. Let's take the next question.
There were a couple of references by members of the panel to the Velasquez case, which was the case on the Legal Services Corporation. And Justice Kennedy, who wrote that opinion, has a couple of paragraphs saying basically this is about protecting the courts and protecting judicial independence. I wonder if the panel members would comment on whether that limits that precedent, because it has not been cited very much in the later cases.
Lillian?
Yeah, I'll comment on that. I think Velasquez is just an impossible case to justify, because he said the argument that he made was that it distorts the legal process, it distorts the course of normal litigation. There was one condition that the court found to be unconstitutional. There were 7, I think it was, wasn't it, Frank? 7 conditions on how legal services corporations, legal services funded by the federal government, could spend the federal government's money, and they restricted all kinds of things. Class actions, any representation of a criminal, a whole bunch of activities that private litigants can engage in, and why the one condition is designed to distort the legal process or the legal profession, and the others are not. I never could understand, and I couldn't explain, but it always seemed to me that given the political context, and maybe we're not supposed to look at that, but the political context of those restrictions on what legal services recipients are permitted to do suggests to me that they wouldn't have gotten any money if Congress hadn't been able to impose all of those conditions on them, because at that time Congress was seriously thinking about defunding the program completely. So that's part of my problems. I think about this politically. What would be the political implications of of striking down any of these conditions or all of them. And it seems to me that, you know, one thing we might consider is every time you strike down a condition, you should send the legislation back to Congress and let them decide whether they want the statute, the program, to continue without the condition. Of course, that's not severance doctrine as we presently know it, but it seems to me that the judges distort the political process by saying this condition is unconstitutional, it falls, but the rest of the statute stays.
Yeah. David, then Marty.
You know, I don't think Congress did, in fact, cut the funding after the Velazquez decision was decided. And I guess I think the Velazquez decision is, although that is a risk, I would agree, in any case in which the court strikes down part of a statute, but what else are you going to do? But I think the Velazquez case is actually consistent with what I was sort of suggesting at the close of my talk, which is this notion of there are certain spheres in which it is particularly important that the government maintain neutrality. And when the government's funding conditions are controlling what arguments a lawyer can make in a case representing an individual, it wasn't that you can't represent this individual, you can represent this individual, but you can't make certain arguments, that skews the legal forum, which is a forum in which the government should not be skewing the arguments that are presented to the court for decision. In the same way that I think the press is a particular sphere of neutrality, and therefore it's no coincidence that some of the first and earliest cases striking down conditions on subsidies or content restrictions on subsidies that could have been defended with a he who pays the piper calls the tune argument involve mailing subsidies to the press, tax exemptions to the press, a funding regime for public radio and the like. So I think this is consistent, that there are certain areas, I would say academia, the academic freedom doctrine falls within this, the press, and the legal forum are certainly three where it's particularly critical to keep to neutrality.
Yeah, Marty.
I was just going to add that I think looking at three cases together, Legal Services versus Velazquez, Christian Legal Society, and Rosenberger, they reflect, I think Justice Kennedy would say, that they are all very much of a piece, even though in Rosenberger he strikes down the condition, and the other two he upholds, I'm sorry, in Velazquez he strikes down the condition. He upholds the condition in Christian Legal, but if you read his opinions in those cases, in his mind, if the government is using its largesse to set up or promote a speech forum, and which is what he thinks is going on in CLS as well, to a certain extent, right? It's this pedagogical give and take. That conditions that would distort the ordinary workings of that forum, either through viewpoint discrimination or by allowing you just to speak to your own, right? In Christian Legal, he says, a vibrant dialogue is not possible if students wall themselves off from opposing points of view. He could have written that in Rosenberger or in Velazquez too. So his view is that when the government is setting up a vibrant, dynamic speech forum, the conditions that promote that vibrancy and that wideness of birth are okay, and the conditions that restrict it are not. So I think he would think of them all of a piece.
I think we have time for one more question.
All right, thanks. This will be short. I didn't hear all of the discussion, but I was very taken by this comment that Justice Kennedy made that you're referring to at the end, because it sounds to me as if what he is looking for, which is having students exposed to all different points of view, is made impossible by this ruling. If you have a Christian legal society which is going to be overtaken by Unitarians, so to speak, so it ceases to be a Christian legal society, you're not getting vibrant views, you're getting ideological amplification of the prevailing ideology at Hastings and a homogenization of all of the potentially different viewpoints and groups. Now, I don't know to what extent common sense has taken flight at Hastings in terms of the way students actually behave with respect to this rule, but I did want to bequeath that analysis to any lawyer in the room who might be arguing a similar case in front of the Supreme Court and you want to get Justice Kennedy's vote.
That argument was actually prominent in the case, and so both Justice Kennedy and Justice Ginsburg addressed it and said that there were plenty of neutral rules that Hastings could and did apply that would prevent the takeover of an organization by students who didn't believe in its basic mission. And they also said that if that case ever came up, it might present very different questions.
John, last word.
No, yeah, I mean, although I found the response to the majority and Justice Kennedy's opinion on that a little bit dissatisfying, because it said there's really no evidence that they're going to be susceptible to takeover. But, I mean, come on, for heaven's sakes, a Christian Legal Society at the University of Hastings in San Francisco taking a stand on traditional marriage, the likelihood that they get overrun if you have to open up to all members is, I think, pretty serious. And I don't have to have a whole lot of evidentiary proof, knowing what I know on the ground of that town, to think that that's a real risk. And that this notion of diversity means that every group has to have all views instead of different groups have different views is itself a government imposition of a particular significant viewpoint that is hotly contested.
Thank you. Please join me in thanking this afternoon's panel.